To the Queen's Most Excellent Majesty, the following view of the laws and Constitution of England, the improvement and protection of which have distinguished the reign of Her Majesty's Royal Consort, is, with all gratitude and humility, most respectfully inscribed by her dutiful and most obedient servant, William Blackstone. Sir W. Blackstone's Preface. The following sheets contain the substance of a course of lectures on the laws of England, which were read by the author in the University of Oxford. His original plan took its rise in the year 1753. And notwithstanding the novelty of such an attempt in this age and country, and the prejudices usually conceived against any innovations in the established mode of education, he had the satisfaction to find, and he acknowledges it with a mixture of pride and gratitude, that his endeavors were encouraged and patronized by those, both in the university and out of it, whose good opinion and esteem he was principally desirous to obtain. The death of Mr. Viner in 1756, and his ample benefaction to the university for promoting the study of the law, produced about 2 years afterwards a regular and public establishment of what the author had privately undertaken. The knowledge of our laws and Constitution was adopted as a liberal science by general academical authority. Competent endowments were decreed for the support of a lecturer, and the perpetual encouragement of students, and the compiler of the ensuing commentaries had the honor to be elected the first Vinerian professor. In this situation he was led, both by duty and inclination, to investigate the elements of the law and the grounds of our civil polity, with greater assiduity and attention than many have thought it necessary to do. And yet all, who of late years have attended the public administration of justice, must be sensible that a masterly acquaintance with the general spirit of laws and the principles of universal jurisprudence, combined with an accurate knowledge of our municipal constitutions, their original reason and history, hath given a beauty and energy to many modern judicial decisions, with which our ancestors were wholly unacquainted. If in the pursuit of these inquiries the author hath been able to rectify any errors which either himself or others may have heretofore imbibed, his pains will be sufficiently answered, and if in some points he is still mistaken, the candid and judicious reader will make due allowances for the difficulties of a search so new, so extensive, and so laborious. 2 November 1765. Postscript. Notwithstanding the diffidence expressed in the foregoing preface, no sooner was the work completed, but many of its positions were vehemently attacked by zealots of all, even opposite denominations, religious as well as civil, by some with a greater, by others with a less degree of acrimony. To such of these animadverters as have fallen within the author's notice, for he doubts not but some have escaped it, he owes at least this obligation, that they have occasioned him from time to time to revise his work in respect to the particulars objected to retract or expunge from it what appeared to be really erroneous, to amend or supply it when inaccurate or defective, to illustrate and explain it when obscure. But where he thought the objections ill-founded, he hath left, and shall leave, the book to defend itself, being fully of opinion that if his principles be false and his doctrines unwarrantable, no apology from himself can make them right. If founded in truth and rectitude, no censure from others can make them wrong. Contents. Introduction of the study, nature, and extent of the laws of England. Section 1 is on the study of the law. Section 2 is of the nature of laws in general. Section 3 is of the laws of England. Section 4 is of the countries subject to the laws of England. Contents. Book 1 of the Rights of Persons. Chapter 1 of the Absolute Rights of Individuals. Chapter 2 of the Parliament. Chapter 3 of the King and his title. Chapter 4 of the King's royal family. Chapter 5 of the councils belonging to the King. Chapter 6 of the King's duties. Chapter 7 of the King's prerogative. Chapter 8 of the King's revenue. Chapter 9 of subordinate magistrates. Chapter 10 of the people, whether aliens, denizens, or natives. Chapter 11 of the clergy. Chapter 12 of the civil state. Chapter 13 of the military and maritime states. Chapter 14 and servant. Chapter 15 and wife. Chapter 16, parent and child. Chapter 17 of guardian and ward. Chapter 18 of corporations. Addenda. During the progress of printing the work, some statutes have passed, which it is necessary to notice here. The most important is the 6GO 4C16, the new Bankrupt Act, which repeals the 5GO 4C98, of which an account is given in the notes to the 31st chapter of Book 2. The new act exempts from the operation of the bankrupt laws certain descriptions of persons enumerated in Volume 2 at page 477 and 1. That is to say, stagecoach proprietors, brewers, maltsters, scavengers, alum, or kelp manufacturers, persons engaged in drawing and redrawing negotiable securities, brickmakers and lime burners, and include scriveners and calendars. In respect of the first class of acts of bankruptcy, enumerated at page 479 and 2, it adds the qualification of fraudulent to the grants or conveyances, which are there mentioned, and provides that no conveyance of a trader's whole property for the benefit of all his creditors, executed and notified as mentioned in the statute, shall be deemed an act of bankruptcy, unless the commission shall issue within 6 months from the execution. As to the auxiliary commissions mentioned at page 480 and 3, it provides specially that all examinations of witnesses under them shall be taken down in writing and be annexed to the original commission. The 22nd section makes a slight alteration in the commissioner's fees and prohibits, on pain of disability, to act in that or any other commission, the receiving any other than the specified sums, or the eating and drinking at the charge of the creditors or of the estate. The 38th section imposes the same penalty on the jailer in the case of an escape, which is noticed at page 482, number 8. But it is silent as to compelling the jailer to produce the bankrupt to his creditors. The 48th and 49th sections empower the commissioners to pay to the servants and clerks to the bankrupt 6 months' wages in full if so much be due, leaving them to prove as ordinary creditors for any further arrears and to refund to any apprentice. Addenda, whose indentures become completely discharged by the issuing of the commission, a proportionate part of the premium which has been paid for him. The 74th section limits the landlord's power of distress to 1 year's rent, which, by the 5G04, was available for 2. See page 487, number 19. The 82nd section makes an alteration in the law as stated at page 486 and 16, relative to payments by and to bankrupts. In both cases, these, when made at any time before the date and issuing of the commission, are protected notwithstanding an act of bankruptcy, if bona fide, and not being in the first case a fraudulent preference of the creditor, nor in both made with notice of any act of bankruptcy committed. The same rule is also extended to the delivery of goods to the bankrupt or his order. The 131st section provides that no certificated bankrupt shall be liable to satisfy any debt discharged by the certificate upon any contract or promise so to do, unless the same be in writing signed by the bankrupt, or some person lawfully authorized by him in writing. In the 4th volume at page 117, it is stated that the Bubble Act, 6G01C18, was enacted in the year after the South Sea Project. This is an error for the year before. The repeal of the statute or very essential alterations in it are now under the consideration of the legislature. In the same volume, at page 154, it should have been stated that 28G03C38, mentioned in N1 on the offense of owling, was repealed by the 5G04C47, and the offense itself thereby expunged from the statute book. It should also have been stated at page 389 of the same volume that by the 53G03C145, corruption of blood is restrained to the offenses of high and petite treason and murder. At page 338 of the same volume, number 3, reference is made to a pending case in which the demurrer to a plea of autrefois, acquit in misdemeanor. The judgment was for the Crown. It has since been decided that such judgment is final. R. V. Taylor, 3 B&C 509, Temple, June 20th, 1825.